So the Supreme Court has granted review to the next big Second Amendment case, and once again it deals with state concealed carry laws and direct defiance of some states after the Supreme Court issued their 63 ruling in New York State Rifle and Pistol Association versus Bruen. And now this case is set for oral arguments at the beginning of next year. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply subscribing to the channel. Also double check to make sure YouTube is not unsubscribed you, because that happens to a lot of people. And also, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to protecting yourself in a self-defense incident, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always expanding upon their benefits and things that you get through your membership. And right now they have a new benefit where if you're in a self-defense case, they will guarantee that you get 4 self-defense attorneys for your case. That is something that no one else can offer. So if you're interested, check them out using the links down below. You can also use my code ARMEDSCHOLAR to get $50 off of an individual sign-up plan or $25 off of a family plan. So as I mentioned in the intro, the Supreme Court recently granted review to the next big Second Amendment case, and once again, it deals with concealed carry restrictions. This case is called Woolford versus Lopez, and it's a case that deals directly with some state laws that were passed in direct defiance to what the Supreme Court said in Bruen. States like New York, New Jersey, California, Hawaii, and others passed hyper-restrictive concealed carry laws after the Supreme Court issued that ruling. The Hawaii Woolford versus Lopez case sought emergency Supreme Court intervention, which surprisingly was granted review by the Supreme Court. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states and their catch-all public property bans are permissible under the Second Amendment. Now, recently, to the surprise of many, the Trump DOJ and AG Bondi actually stepped up in support of this challenge, and they called for the Supreme Court to grant review to these state bans on concealed carry. Well, that appears to actually have paid off. The Supreme Court, in a very surprising turn of events, decided to grant emergency review to this case. This grant of Supreme Court cert actually breaks the Supreme Court's track record of avoiding these types of interlocutory cases, these emergency cases, which are not on the final merits. And the Supreme Court has granted review to this case, and now they have set oral arguments to take place on this issue at the beginning of next year on January 20th. And now the parties are submitting their arguments in this case, and they're submitting their positions to the Supreme Court on why the Supreme Court should rule in their favor. Now, if you're not aware, this Woolford case is a challenge to Hawaii's new laws on concealed carry that were passed in direct response and defiance to Bruen. This law, like many others in other states like California and New York, tried to add more restrictions to concealed carry and create a default rule where individuals can carry firearms on private property only if the owner of that property provides express permission for the individual to do so. Plaintiffs in this case sued the state of Hawaii to strike down that law, and on review, the district court issued a TRO, which was later converted to a preliminary injunction. That was then appealed up to the Ninth Circuit and was reviewed along with the California concealed carry ban, which is a law put in place in California, which is pretty much identical to Hawaii's with a little bit of variance. And on review, the Ninth Circuit upheld the catch-all property ban in Hawaii and reversed the injunction that was issued by the lower court. The Ninth Circuit relied on older restrictions on hunting on private property to actually support that statewide concealed carry ban in Hawaii. Now, after that, the plaintiffs then asked for the Ninth Circuit en banc panel to review this case, but they denied review. They didn't even want to take a look at that ruling. That led this case to then seek emergency Supreme Court intervention. Now, like I mentioned, this case kind of had a hard road ahead of it because the Supreme Court traditionally did not grant review to preliminary injunction cases, to these interlocutory emergency cases. However, the United States government actually supported this case, and they pushed the Supreme Court to grant review to this issue. And the Supreme Court broke their tradition and actually granted review to this case. That is likely because of the concessions made by Hawaii in the Ninth Circuit, and because the trap that the plaintiffs kind of caught them in with the support of the United States government. Now, one of the interesting things that the brief actually did as well is the Trump DOJ said that the Supreme Court should not avoid this case. They should still take it on an emergency basis, and that essentially Hawaii conceded already that nothing else needed to be developed at the lower court level, and they told the Ninth Circuit that expressly, and so there was no need to kick this case down the road and wait for it to further percolate down below at the lower courts. Instead, it was time for the Supreme Court to step in and review this issue. That was likely critical to break through Hawaii's arguments that the petition should be denied for further review by the lower courts, because again, Hawaii conceded that that was not needed at the Ninth Circuit level. Ultimately, the Supreme Court disagreed with the state of Hawaii and actually granted review to this case. Now, the question the Supreme Court will consider and address in this case is whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to public unless the property owner affirmatively gives express permission to the handgun carrier. That means that the Supreme Court will directly address the catch-all property bans passed in defiance to that Bruen ruling. It also is very likely that this decision by the Supreme Court will dig deeper into the prior Bruen decision, outlining more deeply and developing more, how this needs to play out post-Bruen. And this case, like I mentioned, will now be argued in front of the Supreme Court on January 20th. That is when the oral arguments have been set. Now, recently the plaintiffs, in this case, Wolford, submitted his arguments to the Supreme Court on why the court should rule in his favor. In that brief, he states that 45 states respect the right of their citizens to carry arms for self-defense onto private property open to the public. 5 outlier states, Hawaii, California, Maryland, New York, and New Jersey, have defied Bruen by enacting a new default rule that bans carry by permit holders on private property unless the permission is obtained from the owner. These same states had May issue discretionary carry permit statutes of the type invalidated in Bruen. Each of these states reacted to Bruen with defiance, enacting legislation designed to thwart the general right to carry recognized in Bruen. They point out that Hawaii has some of the more egregious carry laws that were passed post-Bruen, and again, all of these states did this in response to what the Supreme Court said. They did not want to make this shall issue, so they did anything that they could to restrict the access to concealed carry. The plaintiff goes on to point out in this brief that the Ninth Circuit found sufficient 2 outlier laws separated by almost a century. One law was enacted by a former Confederate state prior to the readmission to the Union and for the purposes of denying former slaves of their rights to bear arms. The second was enacted to deter poachers from hunting game on private land closed to the public. They state that both laws failed to meet Bruen's how and why metrics. Rather, Hawaii's law was enacted for the avowed purpose of discouraging trained and vetted permit holders from exercising Second Amendment rights newly recognized in Bruen. Hawaii's law thus illegitimately criminalizes the exercise of a fundamental constitutional right without constitutional justification or historical support. Therefore, they argue the Supreme Court should reverse what the Ninth Circuit said. So briefs are now being submitted to the Supreme Court for their oral arguments that are going to take place in January in this case. And soon Hawaii will file their response brief as well. And I also anticipate a lot of amicus briefs will be submitted to the Supreme Court. And there is likely also going to be an amicus brief filed once again by the Trump DOJ in support of the plaintiff here against the state of Hawaii. And I also anticipate that they will probably also ask for permission to participate in the oral arguments in front of the Supreme Court. So you would likely have the Trump DOJ saying that they're going to file a brief, they'll file that brief, and then also say we want to participate in this oral argument in front of the Supreme Court and argue that these type of concealed carry laws violate the Second Amendment. So that's something we're going to be watching out for and keeping our eyes on. So again, a huge Second Amendment case that is moving forward. This is huge for 2A analysis going forward. And it's going to be interesting to see, how does this ruling play out? How do those oral arguments play out? And what additional language might we get in that decision by the Supreme Court that could impact other 2A cases going forward? So as we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the 2 videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.